Good afternoon, everyone. I'm John Carlson. Hello, Judith. Nice to see you. I just saw you sitting there. It's great to see all of you. I am John Carlson, no relation to Tucker. I am director of the Center for the Study of Religion and Conflict, and it is really good to see all of you here in person. At this, our first event of the new school year, that I promise you will not disappoint. The new school year is always such an exciting time. You know, kids are returning to the classroom and the schools are abuzz with activity. In fact, do you know what zombie parents do this time of year? They go to eat the teacher night. I'll be here all week. Okay, moving on. All right. That works better in the trial audiences. Okay, anyway, tough crowd. All right. Today's event would not be possible without the incredible team that we've got here at the center, led by Carolyn Forbes, sitting over here to my right. And I'd also like to extend a very special welcome to Dawn Beeson, who is our new communications manager out there. You can see her with the camera. Welcome, Dawn. She's been working tirelessly for almost all of the summer since she joined us here and has almost earned her first weekend off. Please, if you would, remember to turn off or silence your cell phones. I know you all have had them for 25 years now, but it never fails. Someone does forget if I don't make the announcement. And I also want to mention a couple other events coming up that will be taking place on Thursdays, 1:30 p.m. here in West Hall, 135. On Thursday, October 13th, sociologist Samuel Perry will be giving a talk entitled Power in the Blood, How White Christian Nationalism Threatens Democracy. And then on November 3rd, we will have the Hart Nikachos Lecture in Peace Studies with David Livingston Smith, who is a philosopher seeking not just to impact the world, but also to change, not just to interpret the world, but also to change it. He is the author of a book entitled On Inhumanity, Dehumanization, and How to Resist It. As always, details about our events can be found on our website. You can also follow us on Facebook and Twitter. You can get videos of our past events on our YouTube channel and find all sorts of important and interesting information there. Today's event is being live streamed, so a special welcome to our digital audience. If you want to participate in the Q&A, you can email a question to csrc@asu.edu. You might put question in the subject line so we know how to get to that and are looking for it. And then for those of us joining in person, please stick around for a brief reception in the lobby afterwards. Sadly, those of you who are watching online, we have not figured out how to transmit the cookies and coffee over the live stream, so another time perhaps. Finally, I want to thank all of our friends of the center who are here today and who have been generous supporters over the years through supporting our student scholarships, our research initiatives, and programs like this. If you are not already part of this august group, I invite you to join us and invest in our community and in the enrichment of our civic life together. So a few words now about today's topic and our lecture. This lecture is part of the Recovering Truth project, which is sponsored by the Henry Luce Foundation. And this project brings together journalists, scholars, students, and citizens to consider how the commitment to truth, whether that's truth-telling, truth-seeking, truth-bearing, bearing witness to truth, are vital to democracy and also to the institutions and the culture that sustain it. As a scholar of religion, I know something about the role religion can play advancing democracy and certain kinds of truth claims, as we think about perhaps the opening lines or those important lines of the Declaration of Independence. We hold these truths to be self-evident. And of course, we also know that religion can sustain anti-democratic forces that trade on or foment lies, bigotry, and violence. Today, however, we'll be considering how law upholds democracy and helps to tether us to truth or to some kind of common body of public knowledge. Of course, law can also serve to obscure the truth, as we've seen in some of the recent public arguments regarding the former president's legal woes and the gyrations of his legal team. We need to get the law right for it to do its job. It is that kind of deep concern with getting the law right that first drew me to Professor Greene's work, and particularly thinking also about getting the Constitution right. Jamal Greene is the Dwight Professor of Law at Columbia Law School and has written an extraordinary book entitled How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. That's what it looks like here. A book which critics have called essential, fresh, vital, and deftly argued. It examines how our ideas of individual rights have become so distorted or out of whack. He warns that the proliferation of strong rights claims can frustrate the democratic will, can erode the solidarity of communities. Too often, conflicts over rights encourage us to take aim at political opponents rather than to speak with them. And worst of all, a preoccupation with rights, distortedly conceived, can undermine justice. So to illustrate this briefly, think about how defending freedom has become, in popular culture and discourse, has become synonymous with defending individual rights. We have fiery debates over the right to an abortion, to own firearms, to free speech, or to refuse a vaccine during a pandemic. Many of these debates presume that an individual right is absolute. It cannot be infringed. The only question then is whose rights will trump others? What I would add to this picture as a topic of our Recovering Truth project is a related phenomenon, and that is in which different political tribes create or sustain realities, if you will, competing realities that reinforce their preferred right claims. That is, tribes of like-minded citizens with similar demographics, political leanings. They share common news feeds, social media, social networks that serve to elevate certain rights claims at the expense of others. Greene's book, How Rights Went Wrong, shows us how this individualistic or even tribalistic approach underplays the vital role that rights play in forming the basis of collective self-government. That is, the framers weren't only or even primarily concerned about protecting individual freedoms, but also providing a shared political framework for a free people to think about, live together, and work out their conflicts. Such an approach, I would argue, is essential for understanding how rights reinforce democracy and self-rule, and this also presupposes that we have some kind of shared account of a reality that a common life we share, public knowledge that we share. All of that is needed to resolve our differences. You're not here to listen to me, so I'm going to be quiet, but I did want to say a few words about what I took to be really important takeaways from his first book. Today, Professor Greene is going to be giving you a preview of some work in his upcoming project, his next very ambitiously titled project entitled Saving the Constitution. So if you would, please join me in welcoming Professor Jamal Greene.
Thank you. Thank you to John. Thank you to Carolyn, who was here a moment. She's out of the room now, for all your help in bringing me here. And thanks to all of you for being here. I should start, just as long as we're giving family confessions. I am not related to Marjorie Taylor Greene. Different line of the Greenes. I want to talk about what is, I think, ultimately going to be a somewhat uncomfortable subject, which is about the Constitution, and I'm going to say some not very nice things about it. But at the end, the hope is that I'll be able to redeem it in some way, and try to say something about the conditions for redeeming it or saving it, which I think won't be the name of my project, but is the name of my talk, Saving the Constitution. So what I want to especially talk about is the relationship between the Constitution that we have and diversity. And when I say diversity, I mean diversity of all kinds. The fact of difference between people, including ideological difference between people. A Constitution is a charter of self-government, at least in constitutional republics, such as we often call ourselves or describe the United States. The Constitution is and should be a Republican document. So in that sense, its legitimacy rests on the consent of the governed. Now, this has long been recognized as a bit of a problem, of course, because neither you nor I consented to the Constitution or to being governed by it. But this has been, again, recognized as a problem for a long time, one that I think is an especially problematic problem for our Constitution. It's a problem for all constitutions. And there are at least 4 basic strategies for trying to overcome the problem of consent in a constitutional democracy. Again, the problem that we don't actually consent to the Constitution itself. 2 of these strategies relate to constitutional design, and 2 of them relate to constitutional interpretation. On the design side, one strategy is to make sure that the Constitution's drafting and its ratification reflect a kind of extraordinary supermajoritarian moment. If you get lots of diverse thinking constituencies together and they reach a very high level of agreement, we can be assured that a suitable range of interests has been represented and considered, even if the people in the here and now did not actively consent to the document. So that's one strategy. A second strategy for kind of overcoming this problem of consent over time is to rely on the process of constitutional amendment. Right? The way a constitution can respond to changes in values, changes in commitments, changes in the demands that a nation's people place upon it, is to provide for a process through which people can readily register those values and commitments and demands whenever there's kind of a broad agreement about them. These 2 design strategies, right, one having to do with supermajoritarian drafting and ratification, the other with amendment, are not mutually exclusive. And ideally, one would design a constitution in a way that reflects both cross-sectional and supermajoritarian agreement, and also provides for an amendment process when things change in serious ways. And many modern constitutions are designed in exactly this way. Now, before getting to the other strategies for overcoming the problem of consent, it's important to recognize the degree to which these first 2 strategies don't work for the US Constitution, or are a special problem for our Constitution. We often speak of the Constitution's provisions as if they represented a supermajoritarian commitment of, quote, the people, right, to a set of entrenched arrangements. But this is not true, and it's obviously not true. The Constitution and nearly all of its significant amendments, including the 14th Amendment, which we valorize, was drafted exclusively by white men who represented white male voters. The original Constitution was created by states that generally allowed only propertied white men to vote. Women, of course, could not vote until the 20th century. Black men did not achieve the formal franchise until after the Civil War. Majority of black Americans were excluded from voting until the 1960s. And this is not just a kind of a process problem. It's also a substantive problem. So substantively, the Constitution is, as drafted originally, is adverse to the interests of many of the people who its drafters excluded from political participation. Specific provisions make it difficult for states and Congress to pass debtor relief laws, reflecting the exclusion of poor people from voting at the founding. James Madison brags in Federalist 10 about this, that preventing economic equality through legislation was one of the main purposes behind the Constitution's particular design strategy. The interests of black Americans have been stymied by equal suffrage in the Senate at numerous junctures through US history. This is not unintentional. The 3/5 clause, famous 3/5 clause, is partly responsible for the fact that 13 of the first 15 presidents, all the 15 before Lincoln, supported slavery, and the 2 that didn't were not reelected. Right, so again, the consent problem is substantive. It's not just a procedural problem. It might well be the case, right, that there are provisions of the Constitution that were in fact supported by a supermajority of Americans. But the key point here is that the presence of those provisions in the Constitution is not very useful evidence of the fact that they were supported by lots of people. And likewise, the absence of particular provisions from the Constitution is not evidence of a lack of comparable support. Consider, for example, the Equal Rights Amendment. which passed both houses of Congress with 90% of the vote in each house of Congress, was supported by Richard Nixon, got the approval of 35 states, representing 3/4 of the US population. And that was at a time when we did not exclude women or blacks or young people from voting. No provision of the formal Constitution has achieved comparably broad and diverse support. I doubt there's any minimally democratic constitution in the world, except for ours, where that level of support would be insufficient to amend the Constitution. Right? So it won't do, right, to say that the formal Constitution as drafted and originally understood represented some kind of supermajoritarian support of the American people. It didn't, right? And to say that it did is not just wrong, but is actually offensive. Now, I don't have to say much about how the US Constitution fares with respect to constitutional amendment, the other strategy I mentioned, because we don't amend our Constitution, unlike the vast majority of countries in the world. This isn't just because we don't have a political norm of constitutional amendment, although we don't. It's not because we are more divided as a people than we once were. We're not. One of the main reasons we don't amend our Constitution is because once you refuse to exclude potential dissenters from political participation, then amendment gets a lot harder, it turns out. There are simply too many ways for politically empowered minoritarian interests to exercise vetoes in our system for the current amendment process to be viable. In any event, it's especially problematic from a consent perspective to have a very high amendment threshold, which we do, just about the highest in the world, but a relatively low threshold for the original constitutional design. Right? Remember again, the constitutional creation only required the agreement of a significant majority of propertied white men. The threshold for amendment, by contrast, requires a far larger and far more diverse coalition of people. So the two design strategies for preserving the legitimacy of the Constitution as a charter of self-government fail, right, in the case of the US Constitution. What's left then if we want the Constitution to be legitimate from the perspective of consent? Are a set of interpretive strategies. Right? If the Constitution didn't have consent at the time, perhaps it can be interpreted in a way that meaningfully captures consent over time. Right? Trying to do that is not just a kind of policy preference or a way of reaching certain favored outcomes. It's what is needed to save the Constitution from a kind of despotism of ancient political minorities. Now, note at once that the ascendant interpretive method on the current Supreme Court, which is a kind of originalism, it's in the family of originalism, it's not just one thing, is incompatible with a strategy that seeks to capture consent over time. Right? Originalism requires that we believe in the legitimacy of the Constitution as originally designed, or at least that we take its legitimacy as a given, that we don't question its legitimacy, whether or not we actually believe in it. Now, what I hope to have established so far is that whatever else originalism might have going for it, and I do think it has some things going for it, this particular method does not permit us to use the Constitution as a mode of self-governance. Right? Through the originalist method, even if it's done well, which it usually isn't, modern governance is constrained and shaped by a kind of arbitrary fiat and stipulation, rather than through any kind of democratic consensus. Sometimes originalists claim that there is no serious alternative to their method of interpretation. This is, of course, wrong. There are many other methods, at least two of which I want to say something about today, that are better suited at redeeming the Constitution's relationship to the people it governs. Both of these methods are fundamentally small c conservative in ways that originalism, which is a reactionary rather than a conservative method, is not. The first method is a kind of, you might call it a kind of judicial minimalism. Right? If the Constitution can't be trusted to register the consent of actual supermajorities of Americans, maybe we should be highly deferential to political institutions that can be trusted to register democratic consent. Now, this particular strategy comes with some caveats and qualifications. So First of all, we live in a federal system. So we need to develop some theory as to whom are we deferring, right, as between national and state and local institutions. It's reasonable, to my mind, to say that insofar as we're talking about a national constitution, right, deferring to Congress, right, stands on a different and I think stronger footing than deferring to the laws and practices of some individual state or the people of some individual state. But insofar as both the formal constitution and national political institutions might be silent on some matter, right, deferring to states may have a lot going for it as well. The other caveat and qualification that I have to offer to this kind of minimalist strategy is that if we think the Constitution doesn't actually reflect any special supermajoritarian consent or commitment, and again, unambiguously, it doesn't reflect that, then the very political and electoral arrangements through which we register popular support are themselves suspect. Right? Why have a bicameral national legislature? Why have equal suffrage in the Senate? Why have a federal system at all? Why have a presidential rather than a parliamentary system, and so forth? Right? No supermajority consented to those arrangements at the time they were put in place. Now, I'm not going to go too far down this road. I'm not a nihilist. I'm not an anarchist. The forms of support that pass through these particular institutional forms that we have in the United States have to carry some weight. But the point is that we should be cautious in saying, for example, that legislation is dispositive of, is the be-all and end-all of popular will, or that it's the only interesting form that popular support might take. We'll want to look for other forms as well. Now, the present Supreme Court is obviously very far away from the kind of minimalism that I have just described. The Roberts Court invalidated a provision of the Voting Rights Act that had passed Congress with overwhelming majorities. It invalidated a provision of the McCain-Feingold campaign finance law that had extraordinary bipartisan support. This is Citizens United. Had been signed by a Republican president, had taken years to pull through the Congress. It invalidated a major piece of the Affordable Care Act, even though that too had very significant filibuster-proof majority in the Senate, was the subject of a presidential electoral mandate. But all of those laws, all national laws, all of those laws were supported by larger, broader, and more diverse cross-section of Americans than any of the constitutional provisions that were used to invalidate them. Now, I said there were at least two interpretive strategies. Minimalism was the first. The second, I'm going to spend the rest of my time on because it requires some time to unpack. And for our purposes, I'll call it democratic constitutionalism. That's not my term. Others have used that term as well. But it tries to capture a certain idea, which is the idea that modern interpreters, including courts, should try to make space in all of their decisions for the deep and broad commitments of the American people to be reflected in some way. Now, as I've noted, those commitments are not reflected necessarily in the formal Constitution, but they might be reflected in other ways. Now, in a lot of important ways, courts have been doing this for years, but they've lacked an especially strong theory to legitimate this particular practice. The Yale law professor Bruce Ackerman and others have noted the ways in which the Supreme Court's approach to the modern welfare state, right, for allowing for Social Security and allowing for Medicare, allowing for the Fair Labor Standards Act and health and safety measures at the state and local level, and so forth, allowing for those kinds of legislative achievements reflect commitments of the American people that were never formally constitutionalized and may well be inconsistent with the original understanding of the Constitution, but were reflected, according to Ackerman, in the 1936 presidential election and in its aftermath. I'm speaking today in a very similar spirit as Ackerman, but one that is less focused than he is on formal political developments like national elections, like the 1936 presidential election. I'm also very keen to describe and try to articulate what I'm referring to not as a kind of constitutional evolution, as if we believed something back then and now we've come to believe something different, but rather as vindicating a promise of self-government. It's about inclusion. We were exclusive before and we are inclusive now, and that entails a different set of commitments to be identified as constitutional. Now, here's an example of what I have in mind. In the 1860s and 1870s, there was a wide-ranging discussion of what the post-Civil War constitutional landscape was going to look like. And as many of you will know, right, a number of formal constitutional changes happened: the 13th Amendment, the 14th Amendment, the 15th Amendment. But there was a tremendous amount of constitutional thinking at the time that was happening outside of the halls of Congress and outside of state legislatures. Talk of what they referred to at the time as so-called public rights, the right of access to public accommodations on equal terms with white men. Talk of positive rights, including the right to education. Talk of rights to farmable land. Talk of the duties of the government to protect people from private predation or private violence. These rights and duties were the subject of constitutional conversation among some Republicans in Congress, among many black civil rights advocates, among many suffragists. Current Supreme Court doctrine today doesn't recognize any of those rights and duties as being covered by or included within the 14th Amendment. But why not? Right? The fact that those communities were formally and immorally barred from political participation doesn't mean that they didn't have commitments, or that those commitments don't matter, or that they don't count as part of the American people. And given the number of white men who shared many of these views, right, there's a strong argument for saying that at least some of these commitments were in fact not only majoritarian, but were supermajoritarian at the time. But there were problems of the lack of formal political participation. So the problem with incorporating these kinds of perspectives into our constitutional law doesn't, at least to my mind, sound in morality or political theory, both of which I think require that we accord some weight to the views of people who were immorally excluded. The problem is instead a practical one, right? How are judges supposed to figure out what the American people have committed to if they didn't write it down into the Constitution, if the only people who got to write it down were a small subset of those people? Now, before responding to that challenge, right, note again that originalism is an especially problematic response to this practical problem. To say that we should simply not incorporate broad, diverse perspectives into our constitutional law is to deny the core of the problem that seeking to incorporate those perspectives is trying to rectify. If we really care about certainty and predictability, as many originalists do, we can achieve that in other ways. We can achieve that through minimalism, the strategy I referred to before, which, unlike originalism, at least has self-governance going for it. So if not originalism and if not minimalism, then what? This is in many ways what this book is about. Thanks for bringing it along. And the book starts from the premise that when it comes to the kinds of rights conflicts about which we have deep and inevitable disagreement, we don't have a reliable and satisfying way of choosing one or the other side of the rights conflict. Right? We have diverse and often competing values and commitments. And because we disagree so strenuously about what those values and commitments require, we need strategies that enable legal decision makers, including judges, to exercise careful judgment, right? To act incrementally, to act with a degree of humility and respect towards pluralism and difference between us. I think American courts have, by and large, failed to do this adequately, and that their failure to do so has contributed to polarization, has contributed to mutual distrust. Now, what do I mean by that? There are at least three features of how we talk about rights that I want to focus on as especially common and especially problematic. One feature is that rights are understood to be presumptively absolute. Right? They're trumps. This is a big part of why they are such a pervasive part of our political discourse, whether it's free speech or guns or abortion rights. Right? Once it's recognized that I have a right, then we think that I should win, right? Unless there is some really powerful reason why I should not win. And this means that whether I hold a right, the question of holding a right becomes incredibly important. And I'll return to that problem in a moment. The second feature of rights that I tend to believe, and our courts certainly reinforce, that we tend to believe, not me, is that rights are identified and protected by judges and not by other political institutions. If a legislature passes a gun control law, or the mayor decides to institute a mask mandate, right, during a pandemic, all of the rights discussion is on one side of the question, right? The right to bear arms, the right to not wear a mask, the individual right. There's no discussion of the political decision to protect rights to personal security or rights to health, right? Those rights, in my hypothetical, are being pursued in just the way that most rights are actually protected in our system, namely by passing laws, not by going to court. Right? But our discourse does not see governmental, executive, or legislative action in rights terms. This has a consequence, namely that the way we tend to talk about rights ends up being judicialized. Right? So rights become questions of legal interpretation, and often quite dry legal interpretation. Questions of the text, the constitutional text, which most of us haven't read. Questions of the founders and what they believed. Most of us can't do that kind of historical inquiry. But of course, whether a right to bear arms extends to concealed carry, right? Or whether and under what circumstances abortions may be prohibited, and whether race-based affirmative action should be permitted at public universities, right? These are not sort of intelligibly questions of what James Madison believed, right? They're not fairly answered by the constitutional text. I'll just tell you they're not. And as noted, it's deeply problematic from a democratic perspective to try to answer these questions based on originalist thinking. But even beyond that, and the point I want to make for right this moment, is that resorting to originalist or textualist strategies has the effect of removing non-lawyers from the constitutional conversation, as if rights are about what lawyers think they are, as opposed to being about what the rest of us think they are. Relatedly, when you judicialize rights questions, they become understood to be questions that have some definitive answer, because judges have to decide cases before them, rather than rights questions being the kind of thing that is naturally subject to negotiation and compromise and mediation, the kinds of things we do in politics. Now, a third feature of our rights discourse that I think contributes to its polarizing character is that we act as if rights are scarce. And of course, that's in some sense parasitic on the first sorts of things, which is if they're absolute, they've got to be scarce. Right? We recognize implicitly that we can't all have rights to everything, right, because they're going to conflict with each other. And so we conclude that there must therefore be only some precious values and commitments that get to be called rights. And then since there are only some precious values and commitments that get to be called rights, of course we fight about those things and who gets to have them and who doesn't get to have them. Now the problem is that the reason we disagree so vehemently about the rights that we have is not because some of us believe in rights and others of us don't. It's not that some of us are just right about rights and others of us are just wrong. It's not that some of us are the angels and the others of us are the devils. Right? We disagree vehemently about rights because we are different from each other, because we are not the same people, because we come from different communities, because we have different commitments, we have different values, we come from different backgrounds and have different experiences. We are, in other words, diverse. And so are the things that we are committed to, unlike at the founding. Right? So in this kind of pluralistic environment, saying that only some of those values and commitments count necessarily sets person against person and community against community. Now, how did we get here? Right? We often talk about our kind of highly individualized, kind of highly judicialized, quasi-absolutist approach to rights as if it's a kind of gift from the founders, right, that they gave us this absolutist, individualized Constitution, we tell something like the following story. We've got this Bill of Rights, and it's in the Constitution, and it sets out a code of rights that are particularly protected and insulated from the political process. And once you identify one of those rights, you've got to protect them robustly, because the reason they're listed there in the Constitution is to protect them from majoritarian politics. And majoritarian politics are said to defeat the very purpose of having rights in the first place. Now, this may or may not be an attractive vision of rights. I think it's not an attractive vision of rights for a variety of reasons. But my point for right this second is that it's not what the founders believed about rights. Right? The founders believed very strongly in rights, right? But they did not believe strongly in judicially enforced individual rights that were absolute or anything close to absolute. Right? What the Bill of Rights tries to protect are the localized political institutions that would be needed to work out what people's rights would be. Right? The thing they were trying to protect against federal interference was the right to live in a self-governing community. That community would act through its local legislatures and councils. It would act through its juries, and the Bill of Rights is completely obsessed with juries for this reason. It would act through its churches. It would act through its family units, which are also protected in various ways by the Bill of Rights. It would act through its militia, which is why that is in the Bill of Rights as well. Those are the institutions that would determine the metes and bounds of individual rights, and indeed would protect those individual rights from outsiders to the community, including federal judges, who are part of the target of the Bill of Rights. They're who you're trying to protect yourself from. Embedded within the Bill of Rights is a primarily majoritarian, social understanding of rights, not the liberal, quasi-libertarian vision that Americans too reflexively ascribe to the founders today. That's an anachronism. Now, there are lots of problems with thinking about rights in the way that I just described, in this kind of communitarian way, especially in the 18th and 19th centuries. And I touched on some of them already. Most prominently, those self-governing communities that were at the heart of the Bill of Rights were exclusive communities, right? They gave political power only to some members of the community and not others. And many of the people whose rights were most in need of protection were not empowered to participate in self-government. Much of the rest of American legal history after the founding has been devoted to trying to reconcile the framers' Republican vision of rights with genuine pluralism. We're still struggling to try to figure out how to do this. And we have kind of belatedly come to the view, through the work of and struggles of various social movements, that there are certain kinds of rights violations, especially, for example, Jim Crow, especially, for example, McCarthyism, that have to be viewed with utmost seriousness, that's something the Constitution has to be committed to rooting out. We've also, within our legal culture, come to the view that there are certain kinds of rights that don't count at all. And paradigmatically, any of you who've gone to law school will know the Lochner case and the repudiation of the Lochner case in the 1930s. Is the idea that basic social welfare legislation, wage and hours laws, certain kinds of licensing requirements, health and safety measures, right, shouldn't get second-guessed by judges as violating entrenched property rights or rights to contract. And those are kind of the fixed stars in American constitutional law. Take racial discrimination and sedition laws super seriously. Don't take super seriously a right to contract claim being brought against a minimum wage law. Now the problem, and there are a lot of problems, right? But one of the problems is that we don't have a good way of dealing with the very wide range of rights claims that fall in between those poles. In the 1960s and 1970s, there was an explosion of people making various kinds of rights claims, right? Gender equality claims, sexual and reproductive freedom claims, affirmative action claims, claims that laws were disproportionately affecting certain racial groups or religious groups, even though they were not intentionally doing so, certain kinds of criminal procedure or criminal justice claims like Miranda rights and the right to a governmental lawyer and the right to have the government reveal exculpatory evidence, all kinds of free speech claims that would not have been recognized as free speech claims certainly at the founding and not even in the middle of the 20th century, like claims to be able to engage in certain forms of hate speech, free speech claims on campuses, which were just not a thing before the 1960s, claims involving pornography or obscenity, or involving certain kinds of provocative activism, rights claims about trying to get more welfare benefits from the government, right? Not intelligible as a rights claim prior to the 1960s. Government support for religious institutions, exemptions from laws based on religious freedom, access to certain kinds of governmental benefits, like the right to tenure at a public university, for example, or the right to a driver's license, or the right to not have your gas cut off because you failed to pay, and there's a public utility involved. I could go on, right? These are all areas where, well, what the government is doing when they say, you can't have a driver's license if you have X number of infractions, right? That's not Jim Crow, right? That's not a kind of pathological government. But at the same time, the rights being claimed are intelligible as rights claims. I got to get to work or I can't pursue my livelihood, right? It's easy to state that in rights terms. So what do? What we do is we end up fighting about these rather nuanced political questions, but doing so in binary ways, right? So conservatives resort to originalism or to text or to history as a strategy for getting at, well, what are the true constitutional rights? And once you figure out the true constitutional rights, you can exclude the right to abortion, the right to same-sex marriage, and you can include rights to commercial speech or rights to guns, or lately a right to religious exemption from certain kinds of anti-discrimination laws. And on the other side, right, liberals resort to a variety of theories, sort of anti-originalist theories, as a way of getting at what they think the true constitutional rights are, which are the ones that the conservatives want to exclude and not the ones they want to include, right? So in this way, constitutional rights polarization ends up aligning with political polarization over a lot of the same issues, but it does so indirectly, right, by translating political debate into debate about what the framers really thought, or about tiers of scrutiny analysis, very legalistic language. And then lawyers come to believe that those kind of abstract legalistic questions are what rights conflicts are actually about. They're really about tiers of scrutiny. That's what affirmative action's about. Now, there's a way to avoid doing this, I think, and the way to avoid doing this is through strategies of what in foreign legal systems is known as proportionality. Proportionality focuses much less on what is the essential character of rights in the abstract, much less on that, and much more on the relative burdens associated with certain kinds of governmental action. It's relentlessly focused on facts. The many jurisdictions around the world, and just about every one except for ours, that use proportionality tend to be fairly expansive, more expansive than we tend to be, in recognizing rights, but more willing to acknowledge that rights can be limited in recognition of the fact that we have diverse societal commitments, and those societal commitments have to be both jointly recognized, you can't exclude some people from the outset, but also jointly optimized so that they can't be maximized all at once. Now, I'll try to make this somewhat concrete with a practical example and a very controversial example, namely Dobbs. This is the Supreme Court decision overturning Roe versus Wade's recognition of a right to abortion. Now, Dobbs pursues a methodology that is in the originalist family, so declaring that rights to abortion may be found only if we have a long tradition of such rights. Now, part of the problem with this approach is that we don't have a long tradition of women being able to participate meaningfully in politics. So it stacks the deck, right, to require a long tradition of their rights being protected as a precondition for their rights being protected today. Right? So to look only at the state of the law in the 1860s, when women had no voting rights, and in some states still did not have full property or contract rights, is to deny that women have a meaningful role to play in deciding what the Constitution provides. And that's before you even get to the answer to the question, which is hard. Now, the court, the majority of the court, would describe Dobbs as simply returning the issue of abortion rights to the democratic process. And that's true in a sense. But we don't ordinarily think about constitutional rights this way, right? There are many other rights that have been controversial that are not specifically in the text of the Constitution that we don't just return to the democratic process. Think of the right against racial segregation, right? Which is not specifically in the text of the Constitution either, and was very controversial. Now, federal constitutional rights are national, right? They don't yield to state-level democratic politics because they're intended to reflect a deep national commitment. And so the question in Dobbs isn't just a question of should this be democratically decided or not. Right? You've got to make a judgment about whether it's a right or not. And so the question should have been, is there in fact today a deep national commitment today? A deep national commitment to the right of people to decide whether to bear children? At least that's one of the questions in Dobbs. There's more than one question that needs to be asked in a case like that. So if there is such a commitment, then how much does this particular Mississippi law interfere with that commitment? What are the reasons for that interference? Are there ways to pursue those reasons without interfering with the right? Reasonable people will differ on the answers to those questions, right? But that's what people should be arguing about. And the evidence of a basic commitment to reproductive autonomy is quite serious evidence and requires more serious engagement than we saw in the Dobbs case. The right to use contraception, right, precursor to the right that Roe recognizes quite explicitly, is and long has been uncontroversial, despite its lack of specific constitutional enumeration. Until this summer, of course, Roe had been the law for half a century. It was a 7-2 decision at the time, 5 Republican appointees, including 3 of Nixon's 4 appointees in the majority in Roe, 2 Democratic appointees in the majority in Roe. Every one of the 9 justices that decided Roe versus Wade believed that there was a basic constitutional right to have an abortion under some circumstances. The right to have an abortion has consistently, unwaveringly been supported by majorities of Americans since Roe was decided. And when it was challenged in 1992 in a case called Planned Parenthood versus Casey, its core holding was affirmed in an opinion by 3 Republican appointees to the court, all of whom were appointed after abortion became central to the Republican Party's political messaging. And as noted, the Equal Rights Amendment was supported by overwhelming, unprecedented majorities of Americans, and the ability of women to participate fully in the workforce, which is very much at the center of the right to abortion, was at the center of the arguments both for and against the Equal Rights Amendment. That's what people were arguing about, quite specifically. Now, of course, that's just one side of the case, right? Abortion rights are extremely controversial. And the line that Roe versus Wade and Planned Parenthood versus Casey draw, which is the line at viability for when abortion rights must be protected, is controversial, arguably unsupported by strong democratic commitments, right? So you've got a gap between what the court says in those earlier cases as to how far the right goes and what we can identify as profound, deep commitments to the basic right itself. The idea that the American people of 2022 have on the whole and over a long period of time strongly committed to some basic right of reproductive autonomy seems to me to be indisputable. And yet Dobbs ignores either the existence or the relevance of any such commitment. So that doesn't tell a judge how to resolve the case, right? But it does tell a judge that in resolving the case, they have to take seriously the degree to which their resolution is honoring those deep commitments. And so the question in Dobbs should have been, okay, Mississippi has a 15-week abortion ban. Does that take seriously both the rights of women to reproductive freedom and the rights of states to try to protect what their citizens view as potential life? Rather than choosing one of those rights or the other, right, the court's job was to say, in the case before me, to to what degree can these rights coexist? What are the relative burdens on each of these particular rights? Do women still have some core right of reproductive freedom under this particular law? Are there ways for Mississippi to pursue its legitimate interests that are less restrictive, such as by providing meaningful alternatives to termination, child care benefits, employment guarantees, for example, none of which Mississippi provides? Is the state pursuing those potential alternative avenues or not? Instead of asking about and arguing about those questions, which again we'll disagree about, the court awarded total victory to one side of a rights dispute. In some ways, the mirror image of what I think is a mistake that the court made in Roe versus Wade. Sending the message that the Constitution is simply indifferent to the suffering of women who want or need to terminate their pregnancies. There's no matrix or skeleton key, right, that tells us how to resolve difficult constitutional questions. The Constitution presents and embodies not just a very serious challenge of interpretation, but a very serious challenge of representation. Right? For those of us who belong to communities that have been excluded and marginalized for most of US history, that challenge of representation is visceral, right? It's primary. It precedes all other analysis. Constitutional interpretation that responds seriously to that challenge requires judgment, right? It requires humility. It requires judges incrementally to build out a constitutional law that is not just focused on ancient scrolls or on the placement of commas, which have nothing to do with our rights, but is instead focused on what kinds of burdens on people our society is prepared to tolerate and what kinds of burdens we are not prepared to tolerate. I look forward to your questions. If we have time. I wasn't timing myself, so.
We certainly have time for questions. So thank you so much for a very stimulating conversation. If you would, raise your hand and I'll start working the room. I'm going to move over on this side and come over this way. You can briefly introduce yourself and offer your question. And hopefully you'll take your answer off the air, if you know what I mean.
Thank you so much, Professor Greene. I'm Tracy Fesenton. I'm here at the Center for the Study of Religion and Conflict. I've been very heartened by the response of American historians to Dobbs. As you've pointed out, the decision in Dobbs is that abortion is not a constitutional right, and yet women who might have sought abortions at the time that the Constitution was brought into being were not considered political participants. So we've seen wonderful work by historians of colonial America who have pointed out that 18th century almanacs, for example, were very candid about recipes for abortifacients that appear in many of these almanacs, including one associated with Benjamin Franklin. Historians of slavery have pointed out that women who were enslaved on plantations and miscarried were punished if it was suspected that they brought on the miscarriage in some deliberate way, because that would be to deprive white men of property. And so the induced abortion would be seen as an affront to the property rights of white men. So these forms of history are different. I think Alito was perhaps not the best historian in the examples that he musters in the Dobbs case, and I appreciate the way that they've been supplemented by the work of historians who have responded. So my question, we can take this up in terms of Dobbs or leave Dobbs aside for the moment, but for those of us who are not lawyers, many of us in the room are historians, philosophers, scholars of religion. What can we do to help bring about this reconciliation of our commitment to pluralism with the Constitution's different commitment or lack of a commitment to pluralism?
Well, it's a really tricky question because what can lawyers do is another question that we ask ourselves all the time. And I don't think there's a simple answer to that question. I mean, if one is dissatisfied with how the court is behaving, so one thing is to vote, which is a long-term solution. But beyond that, and as in an academic audience, we can talk in our time frame is longer than that of most. I think it's important to denaturalize the assumption that the Constitution cannot be altered by the people of today. I think that's a terribly pernicious assumption. In fact, it's inconsistent with self-government for reasons that I've described. Now, it's very tricky to figure out, how do you actually come together to actually change the Constitution. I think we have a kind of despair that we can ever sort of agree with each other enough. But what I want to denaturalize is not just the idea that it's possible to change the Constitution, but the idea that changing the Constitution requires that we observe the procedures for constitutional revision that the framers put in place. They didn't observe the procedures for constitutional amendment that were in place before. And as noted, there were very serious problems of representation at the founding. Right? And so, again, I'm not suggesting what form it should take. I think we have to kind of figure that out together as a people and over time. But part of our conversation needs to be, what would it look like to have a constitution that is in fact representative of the full diversity of the American people? And I really do mean not just along the standard lines of race and ethnicity and gender and sexual orientation and so forth, but genuine ideological diversity as well. And there's a constitutional convention movement that's actually quite far along right now. It's a primarily conservative and more libertarian movement because it's entirely focused around a balanced budget amendment. The idea that we can actually change the Constitution is the right idea. The idea that it should only be, according to the Article 5 procedures and about the balanced budget is the wrong idea. Not because that's a bad idea, although it is, but because it shouldn't be limited in that way. We should be thinking much more broadly than that.
I'll take one question here and then start moving this way.
Thank you. Hi, my name is Carol McNamara. I'm the Senior Director of the Center for Constitutional Design at the Law School, which is a very new project. And so your categorization of the challenges was interesting to me. But I also know that you've recently been involved in a project like that with the National Constitution Center, and that you agreed on a certain number of amendments in the end. And I wonder what your reflections are on that project and that ability to agree across these three teams that were invited to write new constitutions, progressive, libertarian, and conservative, because it seems to me that some agreement across those kinds of good government, I guess the libertarian team called them good government amendments, seems to reflect the possibility that there is some way to come to some form of agreement. So I leave it at that.
Yeah, this was actually, I think, turned into a really cool project that I was skeptical about at the beginning. This is through the National Constitution Center in Philadelphia. And the initial charge of the project was we're going to pick three teams that are associated with particular kind of ideological perspectives, one so-called progressive, one libertarian, one conservative. And they'll draft their own constitutions with no constraints whatsoever. And I was part of the progressive team. We drafted a constitution. Each of the teams drafted a constitution. And it turned out that there was actually some overlap in the ways in which these teams thought the Constitution should be revised. And so the next phase ended up being, well, let's call a fake constitutional convention and have the teams come together and see if they can actually agree on ways to amend the Constitution. And we had that convention over Zoom a few weeks ago. And we agreed to very specific language on 5 constitutional amendments. One having to do with judicial term limits, one having to do with the so-called legislative veto, one having to do with impeachment, one having to do with the amendment process itself. Everyone thought it should be made much easier. And the 5th I'm forgetting, but someone will remind me at some point. But the process itself, I mean, part of what was heartening about it and kind of cool about it is, we did come in with different agendas and different views, and those were aired in the room, and there was lots of in-character objections to various sorts of things. But everyone came in with a kind of open-minded spirit and a spirit of compromise and a spirit that, the perfect can't be the enemy of the good. And if we can make some improvements, then the fact that we didn't get the thing we really wanted is okay, because we live in a society, right? And so there are other people who disagree with us. So I thought it was a nice project because it really did show something and was kind of an object lesson in what we all need to do, and what I think genuinely many of us can do, and really can do if we normalize that kind of process. It's going to take a long time to normalize it for lots of reasons, having to do with the gap between where I think most of us are and where the people who seem to be our thought leaders are, and social media and cable news and all sorts of other things that make it appear as though we are much farther apart than we are. We are far apart on lots of things, but we don't have to hate each other.
Thank you very much for your lecture today. I thought it was very thought-provoking. I have 2 questions, real quick ones. First of all, the Dobbs decision, even though I don't agree with how the court got there, based upon your argument today, is it reasonable to make the argument that the court got it right by saying this is really not our issue? When you talk about we're judicializing everything, they basically said, we're not going to judicialize this. This is a decision that has to be made by the people. They can decide however they want. Should courts do more of that, is I guess my question. And the second thing is, I was very interested in listening to your thoughts about how judges should look at what's going on in the what are public perceptions, what are the right things to do. But I'll use Dobbs as an example. In Dobbs, the court could have said there are 15 states that have anti-abortion statutes. As soon as we reverse Roe, they all believe that they should criminalize abortions or prohibit abortions. How dangerous is it, or how do you organize a court or a judicial analysis that includes, this kind of analysis?
Great. So I think that the perspective embodied in the question and also in Dobbs is closer to what I described as the minimalist strategy, which I do think is, if you're going to decide, should we be originalist or should we be minimalist, I'm going to pick minimalist just about every time, because at least that does reflect some democratic self-governance. There's some opportunity for correction through the democratic process for the reasons you described. Now, I'm not a minimalist because I do think that there are rights that do need to be protected from majorities. I named one, which by now we don't argue about anymore, but we argued about quite a lot before, with racial segregation, right, for example, which again is not specifically in the text of the Constitution. There are lots of rights that are not in the text of the Constitution. The right to not have a forcible abortion is not in the text of the Constitution, for example, right? So we have to, there are commitments that we have, the right to raise your own children, right? The right to not be deprived of an education, right? There's like a whole list of things. Now, why are those constitutional rights? Why wouldn't we say, well, whether people are allowed to pursue their education or not is just left to the states? It's not in the Constitution, so it should be left to the states. Well, why don't we say that? We don't say that because we all recognize a certain deep commitment to, at least at some level, right, some degree of autonomy in pursuing one's own education, and not being subject to racial segregation, and being able to raise your own family, and all sorts of things. Abortion rights is a version of that. Now, it goes much further than a lot of people are comfortable with, right? So there are important questions that I think it's actually quite important for the democratic process to argue about in terms of how far it goes. right? So I think, so for that reason, I think Roe is problematic for that reason, is that I think it takes too much off the table in terms of democratic conversation. But that doesn't mean that there's no right at all or there's nothing at stake. The idea that there's nothing at stake is, I think, quite deeply wrong, and again, consistent with lots of other rights that are not specific in the text. There has to be a dialogue between, when I say don't judicialize, I don't mean judges should not be involved at all. I mean that there has to be a dialogue between the political branches and judges. I offer some strategies for how to do that and how to think about that in the book. But that's the basic point.
Hi, my name is Richard Amesbury. I'm a faculty member in philosophy and religious studies here, and really appreciated your talk. I think I agreed with nearly everything you said, but as a result, I wasn't entirely sure why you called your talk Saving the Constitution as opposed to Saving Democracy from Constitutionalism. And there are thinkers who take that view. Samuel Moyne, for instance, the legal historian, has argued recently in the New York Times that we'd actually be better off without the anti-politics of constitutionalism. And as I understood it, your answer to that is, well, constitutional interpretation is important because there's a layer kind of above the merely legislative. There are these sort of long-standing or perhaps more recently arrived at, but nevertheless pervasive sort of political norms. But couldn't you have a kind of system in which those norms function as a kind of unwritten constitution, for instance, and simply not bother with the Constitution as a written text at all? It seemed like the whole thrust of the argument was to sort of take away the idea of the Constitution as an independent variable and place that agency outside the text itself. So I guess my question is, why bother with the Constitution then?
Well, so I think in the way in which you described your question, you've given part of what my answer will be, right? Which is, I'm not committed to the idea that the Constitution must be understood as a written text. So there are other systems, not many, but other systems that don't have a written constitution. The UK being the most famous example, that doesn't have a written constitution but does have constitutionalism, has a norm of parliamentary supremacy, but that doesn't mean that any given parliament just does whatever it wants, right? There are deeply settled understandings. The idea being, if you want to change this, you've got to really mobilize, and everyone's got to know that we're in a special constitutional moment here. That's constitutionalism. So it doesn't need to have a kind of master text in order to satisfy these conditions. And in fact, sort of the first part of the talk was kind of saying, we're not so far from that ourselves. That some of our major commitments that I understand in constitutional terms, the commitment to the idea that the government can pursue a welfare state, the commitment to the idea of that people should not be separated into castes on the basis of race, the commitment to the idea of the basic ability of women to participate in civil society and in the labor market and in the political process. But those are written into the Constitution, the written Constitution, only thinly, if at all, but I still think they're constitutionalized. So now it may be that Moyne and Dorfler and other people who formally take the position against constitutionalism merely mean that. But if they only mean that, then I'm not that far away from them. But if what they mean is all we care about is sort of a single layer of politics, no one in the world does this except for authoritarian societies. And so there's really quite a lot to be lost from that. Part of what the book tries to emphasize is that part of the role of judges is to set some boundaries on political conversation. That helps to give leverage to different sides of a political conversation so that one is not able to dominate the other, what some have called lowering the stakes of politics, right? That's the role of the court, not supplanting politics, changing its stakes, right, so that it doesn't result in dominance, but results in conversation. That should be the goal. It's tricky. It's hard to figure out how to get there. But I think that that's a more productive way to understand our social commitments.
Hi, Aliana Booman. I'm a 1L at the Sandra Day O'Connor School of Law. Before I begin with my question, I just want to say thank you for coming to speak with us. I'm sure on behalf of everybody here, we are very, very grateful to be in your presence and for you to be able to come and lecture for us. So thank you for that. So my question for you is that we know, as you spoke about the Constitution, how one way that we can go through the Constitution is through amendments. However, as we've kind of seen in more recent years, it seems that politics are inherently intertwined in the legislative process. So when these amendments come forward, some of them, may get passed by the House, but then get shot down by the Senate, or vice versa, because of either various political parties or things that we're not aware of. So how do we reconcile those differences of, okay, politics is going to be intertwined with trying to save the Constitution? However, if we can't get amendments through, like what does that process kind of look like, if that makes sense?
Well, thank you for the question, and thank you for the undeserved accolade. In some ways, I'll go back to the previous question as to why I say saving the Constitution. Why am I so committed to this thing, and not just throw the thing out and let's start over again? And part of the reason is that I think that our history actually reflects a very long-term, very incremental wrestling with these kinds of questions, and that the things that I have recognized as being political but nonetheless constitutional in terms of the welfare state, in terms of black civil rights, in terms of women's equality, have been recognized by courts, have been recognized by politics. And the moment that we're in, and this is not, getting there requires lots of contestation, right? It requires, and the commitments that lead you to say, oh, but I can't get through the filibuster, right? There's a whole host of other people who do not want you to get through the filibuster, right? And they are also Americans, and they also count, and of course you count as well. And so I'll go back to the word kind of, denaturalizing the idea that in our political bargaining with each other, what we are doing really should have constitutional status. And when we actually agree, or when we actually are able to overcome some of these major obstacles, these veto points, and pass major bipartisan legislation, that really should have the status of constitutional amendment, because that really does reflect a commitment, again, much deeper than anything in the actual formal Constitution. So I think we've done that without formally throwing out our Constitution. And so I think there's a way of describing that as consistent with at least one possibility for our constitutional arrangements. Part of the language, the kind of macabre language of saving, right, is to say that if we don't do that, if the Constitution is unable to accommodate broad-based, diverse, supermajoritarian political change, then it's not worth the paper it's written on. It's not ours, and it has to be ours, right? So I also don't want to be written off as just like, oh, he just doesn't care about the Constitution. No, you don't care about the Constitution, is what I want to say. The Constitution that we have developed as a people, right? And that's why I use the language of I'm not against a conservative jurisprudence, even though I don't describe myself as a conservative. I am against a reactionary jurisprudence that says all the progress we've made so far must be thrown out. And that's an existential threat to constitutionalism.
Our last question here.
I'm just a normal person who is walking down the street. I have no academic credentials. However,
And I'm a normal person standing at the podium. Yeah.
no credentials.
Who has a name, I'm sure.
I'm sorry. My name is Mary Marco. And what I keep thinking about is the effect of the judicial system on any of this happening. So the case for Dobbs came out of Mississippi. We realized that Mississippi took until, I believe, 1964 to ratify the amendment on slavery. And it took until 1984 to give women the right to vote. And of course, they're going to have attitudes. And my concern is, you know, we change or try to change things, but how can we do it? There's something like 22 states with 7 million people have equal rights in the Senate, as does something like, I don't know, 100 million people in 22 states, largely populated. And you look at how the people who got on the Supreme Court, and it was through the Senate. And I don't know, how do we fix it with what seems to me a very broken system?
So it is a broken system, and I don't have a lot of optimism to give you. It will take a very, very long time to fix those kinds of problems, if we fix them at all. As to the court, you know, there are things that can be done. They require some serious political commitment, and the Senate being where it is makes that difficult, although the Senate has the power to operate on a simple majority if it chooses to do so. And I think that those mechanisms should be used. So for example, if the Senate were to, the Senate can provide for some basic right to abortion by national legislation. I think there's a very substantial chance that and they'd have to get rid of the filibuster to do that, in all likelihood. But if they were, and that would be bipartisan, by the way, if they were to do that, because there are Republicans who would sign on to that, depending on exactly what it said. There's a very substantial chance, without getting into the constitutional law doctrine, that the Supreme Court would strike that down and say that's not something within the national power of Congress. If the Supreme Court were to do that, I think Congress should just ignore them, repeal their jurisdiction to hear those cases involving that particular statute. Now, that's perfectly within the constitutional bounds. It's against constitutional norms, right? But so is Dobbs, right? So, you know, at some point you have to. I'm not a radical, but at some point you have to play political hardball, and alter the jurisdiction of the court, alter the size of its membership if you need to. I actually favor doing that in nonpartisan ways, right? I think the Supreme Court should have 30 or 40 or maybe 200 justices rather than 9, for a variety of reasons I can get into. And I think that should happen regardless of the politics of it. But there are tools available to sideline the court if Congress chooses to use them.
I know that there are a few other questions, and I know also that Professor Greene is extremely gracious and will entertain your questions even after the appointed hour. But I'm also watching students pass by and maybe taking swipes at the cookies that are out in the reception hall, and we don't want that to happen. So would you all please join me in thanking Professor Greene for his talk today.